Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Here. The chair lays out House Bill 272 by Representative Perez and recognizes the bill's sponsor, the Dean of the Senate, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 272 by Representative Marianne Bettis relates to the prosecution of the offense of fraudulent use or possession of credit card or debit card information. It is a companion to my Senate Bill 807. Members, Texas ranks 8th in credit card fraud with 45,260 reports made in 2022. In 2019, the legislature passed House Bill 2624, which authorized the prosecution of credit card or debit card abuse, defined as the unauthorized use of a physical card or its details, to obtain property or services with the intent to defraud in any county in which the offense occurred or in the victim's county of residence. It also allowed prosecutors to demonstrate intent to defraud any individual or entity rather than a specific person, facilitating prosecution. That year, we also passed House Bill 2625, which criminalized the fraudulent use or possession of credit card or debit card information when someone illegally uses or possesses card data without the cardholder's consent, often through digital means. This statute, however, lacks the same venue and intent flexibility as the card abuse statute, complicating prosecutions. House Bill 272 would align the second bill, House Bill 2625, with a previous bill, which was 2624, so that they both can use the same venue, legislative restrictions and demonstrations of the offense. So it's basically to align the two. That's all.
Thank you, Dean. Any questions for the Dean of the Senate on House Bill 272?
No.
We'll open public testimony on House Bill 272. Is there anyone wishing to testify on, for, or against House Bill 272? All right. Director, come down and have a seat. No, go ahead, have a seat, please. So introduce yourself and tell us who you represent.
Thank you, Mr. Chairman. I am Adam Colby. I'm the director of the Texas Financial Crimes Intelligence Center.
Very well. And so the bill that the Dean was speaking about, House Bill 272, these are the type of prosecutions, investigations and prosecutions that are handled by the Financial Crimes Intelligence Center?
Yes, sir. And in fact, the law that the senator was referring to that was passed in 2019, which we in law enforcement refer to as the counterfeit credit card statute, has pretty much become the gold standard for Texas law enforcement across the state for prosecuting credit card crimes. We used to use 3251, which was fraudulent use, which was really intended more for straight identity theft as opposed to credit card crimes. So adding this into the Code of Criminal Procedure and expanding the venue for its use will greatly enhance law enforcement and prosecutors' ability to fight this type of crime.
Excellent. Senator, if there's any questions for Director Colby? Thank you for being here. Thanks for what you're doing.
Thank you, sir.
Is there anyone else wishing to testify on, for, or against House Bill 272? Seeing and hearing none, public testimony is closed. Bill's left pending this time.
Thank you. Thank you, Mr. Chairman and members.
The chair lays out House Bill 1661 by Representative Vasut, sponsored by Senator Betancourt, and recognize our colleague, Senator Hall, to explain the measure.
I thank you, Mr. Chairman and members. HB 1661 increases penalties for failure to distribute election supplies from a Class C misdemeanor to a Class A misdemeanor, for obstructing the distribution of election supplies from a Class C to a Class A misdemeanor, and releasing election results before the polls close on election night from a Class A misdemeanor to a state jail felony. The bill also creates 2 Class A misdemeanors for, 1, the authority responsible for procuring the election supplies, and for an election commits an offense if the authority intentionally fails to provide an election precinct with the required number of ballots, and the authority responsible for procuring the election supplies for an election commits an offense if the authority intentionally fails to promptly supplement the distributed ballots upon request by a polling place.
Thank you, Senator Hall. Any questions for Senator Hall on behalf of the sponsor on 1661? Very well, we'll open public testimony on House Bill 1661. Call Ed Johnson. Mr. Johnson is the only witness. There he is. Well, that's not him. He's registered to testify on, for, or against House Bill 1661. And we'll show his position for the bill. Is there anyone else present wishing to testify on, for, or against House Bill 1661? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair now lays out House Bill 551 by Representative Swanson, sponsored by Senator Bettencourt, and the chair recognizes our colleague, Senator Hall, to explain the measure.
Thank you, Mr. Chairman and members. House Bill 551 provides the same privacy protections already afforded to individual campaign donors and applies them to the residential addresses of individuals who receive a campaign expenditure. The bill requires the Texas Ethics Commission to redact an individual's residential home address on public reports if they receive compensation. Campaigns would still be required to report those residential campaign addresses. However, the Commission's public report would only include the person's city, state, and zip code, just as is currently done for donors. Oftentimes, campaigns attract young workers who are minors, still living with their parents, or college students living alone. Publicly disclosing their home addresses leaves them vulnerable to harassment or worse by bad actors. Again, this protection is already provided to individuals who donate to a political campaign. It is important to note that this bill only exempts residential addresses from disclosure. An individual or entity that receives money at a non-residential address as defined in the statute would still have their addresses publicly posted on a TEC report.
Thank you, Senator Hall. Any questions for Senator Hall on House Bill 551? We'll open public testimony on House Bill 551, and the chair calls Ed Johnson. Mr. Johnson is the only witness who is registered to testify on, for, or against House Bill 551. I'll ask, is there anyone present wishing to testify on, for, or against House Bill 551? Seeing and hearing none, public testimony is closed. Bill's left pending this time.
Excuse me, I was trying to sign in on this bill for Texas Eagle Forum. It's not allowing me to sign in. It's saying it's closed, so.
We'll have a seat. We'll do a paper card for you, and we'll take you to your testimony. Thanks. Go get your stuff and come on down. Thanks.
I don't have a testimony.
Oh, you just want
to put us in to support the bill.
Okay, so we'll get a card for you to make sure we have it, and we'll show you on behalf of Eagle Forum for the bill.
Yes.
Thank you, Ms. Castilla. Thank you. And public testimony is now closed on House Bill 551, and the bill is left pending.
Adam.
The chair lays out House Bill 2820. Representative Louderback, and recognizes its sponsor, Senator Hinojosa, to explain the measure.
Thank you, Chairman Hughes and members of the committee. Charitable bingo organizations are an important partner in community philanthropy and charity projects, helping to support important community causes in every district in Texas. Currently, a licensed authorized charitable bingo organization is only allowed to retain a maximum of $50,000 in the organization's bingo account for operating expenses. This restriction was implemented by the 81st Legislature in 2009. However, since that time, inflationary pressures and popularity growth of organizational bingo have put tremendous strain on charitable bingo organizations to simply continue operations. HB 2820 would relieve the financial strain on charitable bingo organizations by increasing the operating capital cap from $50,000 to $100,000. I'm pleased to be joined by Texans for Charitable Bingo today, who can attest to the strain placed on their operations by the current cap and the need to expand. The committee substitute simply makes the bill a legislative council draft and makes a clarifying tweak to the caption. Do you have that? Committee sub? We don't have the committee sub today yet. Okay, there should be an incoming committee sub that will make it just a legislative council draft. And with that, Mr. Chairman, happy to answer any questions.
Thank you, Senator. Senator Birdwell, you're recognized.
Just one question. You mentioned, you used the word expand a moment ago. I believe you meant to say increase the threshold.
That would be proper.
Okay, all right.
Thank you for that distinction.
Because, yeah. Thank you, Senator.
Yes,
Thank you, Mr. Chairman.
Thank you, Senator.
Thank you, Senators. Any other questions for the sponsor on House Bill 2820? Very well, we'll open public testimony, and the chair, public testimony is now open. The chair calls Mark Westerman. Mr. Westerman is the only witness who is registered to testify on, for, or against House Bill 2820. Is there anyone else present wishing to testify? If so, please make yourself known so we can come down here so we can hear from you. Mr. Westerman, welcome. You get situated there and introduce yourself. Give us your testimony.
Thank you. Thank you. Good morning, Chairman Hughes, Vice Chair Paxton, and Senators. Thank you for allowing me to speak today. My name is Mark Westerman. I'm a CPA from Victoria and treasurer of Texans for Charitable Bingo. I'm testifying on behalf of myself and this organization in favor of the bill 2820. Texans for Charitable Bingo is an association of charities, lessors, manufacturers, and distributors with a long history of supporting charitable bingo operations in Texas. Our organization represents 2 bingo halls that serve 14 charities in the Conroe and Victoria areas. We are pleased to advocate on behalf of the charitable bingo and organizations that we serve. Each of these 2 units have distributed more than $500,000 annually over the past 5 years to its member charities. In addition, state and local governments received approximately $300,000 from each unit. What does this bill do? The bill seeks to raise the amount that charities are able to maintain in their reserve account, also known as a capital account. This cap has not been updated since 2009, as the Senator mentioned. This small but much needed update will provide a more stable foundation for administering charitable bingo in Texas. It costs approximately $22,000 to operate bingo for 1 week in our halls. Any business interruption, such as a natural disaster like Hurricane Harvey, is the reason that we need to have sufficient reserves to pay the bills while we can't conduct games. It doesn't happen often, but the reserve would be welcome. As an accountant for the 2 units and many of the member charities, I can assure you that this update will be a welcome tool that will enable charities to dedicate sufficient resources for responsible operations, preparing for emergencies, and plan for the future. This bill will not expand gaming in Texas. So charitable bingo supports our local communities and directly contributes to city, county, and state general funds from prize fee winnings. This bill will support the charities we serve with this long overdue update. Thank you, Senator Hinojosa, for sponsoring the House Bill 2820 and appreciate the opportunity to speak this morning. I'm happy to answer any questions you might have.
And thank you for your testimony. Senator Hinojosa, do you have questions?
Mr. Chairman, just to clarify, obviously that was a script error, but this is coming over from the House, so it's not my Senate bill, therefore wouldn't require any committee sub. This is ready to go as is. It's the House Bill's ladderbacks bill that we're sponsoring, so it's ready to go.
Yeah, thank you.
Very good. Senators, any questions for Mr. Westerman? Thanks for being here. Thanks for your testimony.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 2820? Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair lays out House Bill 3181, Representative Dutton's bill, and recognizes its sponsor, Senator Paxton, to explain the measure.
Thank you, Mr. Chairman. Thank you, members. House Bill 3181 addresses a critical issue in family law, the enforcement of court-ordered possession and access to children. By law, a child's best interest is to be prioritized when determining access to and possession of a child. Therefore, ensuring compliance with these orders helps protect the best interest and well-being of children involved in custody disputes. However, the Family Code lacks some needed tools to curtail a repeated pattern of one parent denying the other parent their court-ordered time with the child. House Bill 3181 addresses this by providing stronger consequences if the parent has been held in contempt of court for the denial of court-ordered possession or access to the child at least 3 times previously, including authorizing the court to modify the court order or decree providing for the conservatorship or for time with the child, mandating that the additional access ordered to make up for the denied time totals to twice the duration of the time that was denied, and providing financial consequences by limiting the court's ability to waive attorney's fees and costs for repeat offenders. House Bill 3181 is an important step to ensuring that court-ordered possession and access to children is respected. Members, this bill unanimously passed out of the House Committee on Judiciary and Civil Jurisprudence and passed the full House 135-6. Thank you, Mr. Chairman and members, for your consideration.
Thank you, Senator Paxton. Members, any questions for the sponsor on House Bill 3181? Very well, we'll open public testimony on House Bill 3181. Chair calls Honorable Carl Hayes, George Saldana. And if anyone else wishes to testify on, for, or against House Bill 3181, please come down and let us know so we can get you in the system and hear from you. Judge, welcome. Introduce yourself and go ahead.
Hi, Chairman Hughes, members of the committee. My name is Carl Hayes, and I have the honor of serving as a family court judge of Hays County, Texas. I'm also a member of the Texas Family Law Foundation, but I want to make clear that I am not testifying today in my capacity as judge of the family court in Hays County, nor am I testifying on behalf of the foundation. I did help draft this legislation, which I think is very important. 105.006 of the Texas Family Code provides that in every single order that is rendered by a court involving children and possession and access, the following language is to be included: that failure to obey a court order for child support or possession of or access to a child may result in further litigation to enforce the order, including contempt of court. A finding of contempt may be punished by a confinement in jail for up to 6 months, a fine of $500 for each violation, and a money judgment for payment of attorney's fees and court costs. Unfortunately, those words are meaningless for a large number of individuals who come into court trying to seek enforcement of their possession and access orders. I have lost count of the number of attorneys, and as recently as yesterday, when I was explaining to an attorney that I was going to come testify on this bill, the attorneys tell me, "Judge, you're the only person that has ever held someone in contempt of court for violating a possession order. You're the only judge that we've ever gotten attorney's fees awarded for when they violate a possession order." Because the problem is we've given too much discretion to judges, and so when I was practicing law, and I've been practicing for 40 years, I've been the judge of the family court for 6, but I would routinely have to tell people when they came into my office saying they were trying to enforce an order, well, you know, we can go into court, you're going to spend a lot of money, but you may not get the result that you want because the judge is likely to give them a slap on the wrist. This gives the opportunity for this body to set a public policy to say, we value both parents' rights to have possession and access of their children. We do enhanced penalties on all sorts of offenses. We tell people when they violate DWI laws, we do enhanced penalties for that. We tell people when they can't have probation for certain offenses. This is doing the same thing, and it is endorsing the public policy of the state of Texas that children need two parents in their lives. I'll yield for questions.
Thank you, Your Honor. Mr. Saldana.
Thank you. My name is George Saldana. This session, I've heard passionate debates over gun rights, medical freedom, educational access, and rightfully so. But we must not overlook the most sacred and constitutionally protected rights we have, parental rights. Under this bill, a parent must prove 3 separate violations through contempt proceedings before the court will ever consider relief. That means hire an attorney not once, but 3 times, each costing thousands of dollars. That's simply out of reach for most working class and poor parents. We already have tools to address these violations. The mechanism is interference with child custody under Texas Penal Code 2503. Yet law enforcement and prosecutors routinely refuse to act, telling parents, take it back to court. It creates a financial incentive for lawyers, and it takes away from our parental rights. Let me ask you, would we ever require a citizen to file 3 lawsuits to exercise their Second Amendment or gain access to medical care? Then why are we forcing parents to file 3 costly contempt actions just to see their children? There's a better way. Instead of this heavy, unaffordable burden, the state can allow the police reports to replace the contempt actions to be able to, that's my solution to this bill. I love it. We're in the right direction with parental rights. But ultimately, sir, I do believe that we have viable mechanisms to enforce these court orders. We just need the judicial branch to enforce them for us. Thank you.
And thank you, Mr. Saldana. Senator Paxton, you have the panel.
Thank you. I appreciate it. And Mr. Saldana?
Yes, ma'am.
So you might be happy to know that I actually just, I'm carrying, and we have passed out of this chamber, Senate Bill 2794, which does address exactly, it creates the police report record on the criminal side, but this is on the civil side. And Judge, do you have any responses to some of the things he brought up?
I agree with him 100%. The problem is...
Can you lean into the mic?
I'm sorry. I agree with Mr. Solana 100% because he's saying the problem is we don't have a judge who enforces. And so this forces the judge to enforce the law. It's a 3 strikes and you're out rule. And that's been the problem. Sometimes we get 3, 4, 5 strikes and people consistently, and you heard that. You were the sponsor of Senate 718 last. You heard the stories of the people who for years have been trying to get judges to do something, and nothing happens. And so I think a remedy, and that's why it's great that you're sponsoring, you're carrying both of these, because we need something on the criminal side. We also need something on the civil side. Both of those working together is what's going to help the children of the state.
Thank you. I appreciate that, and I appreciate the issue that you bring up, Mr. Saldana, and I think that's the hope with both of these bills, that it comes at it from both sides. The other one, the 3 strikes policy that is 2794, is not law yet, and so you may not be familiar with that, but I think it will go a long way to help on both sides. And thank you both for being here to testify on the bill. We appreciate it very much.
Senator, if I may,
Sure.
just real quick. I've been in the Harris County Family Courts for the last 8 years, and this is my niche, interference with child custody. I haven't seen my boy in 4 years, and it's routinely just disregarded by some of these judges. And of course, I'm on the judicial accountability for qualifications of judges because I can't miss any more time with my child. And so I thank you guys for all your help.
Thank you. I appreciate, and I'm so sorry about your situation, but appreciate that you're here to testify so that people can know this really does happen. And hopefully this legislation, both of these approaches will go a long way to helping people who are not getting their proper court-ordered time with their child due to interference sometimes with the other parent. Thank you.
Thank you, Senator.
Thank you.
Senator Birdwell, you're recognized.
Thank you, Mr. Chairman. Judge, you said you weren't here to testify in your capacity as a judge. I hope you don't mind if I ask you questions in your capacity as a judge.
I can answer questions, but I'm not here officially as a representative
I
of this county.
understand, but I'm going to ask you about your experience. But first, let me say, not too many people come in and say they want less discretion. And so, and given the nature of what you're describing, what we're looking for is faithfulness. And what I think you're complaining about is sort of the lack of faithfulness to a court order.
Yes.
So let me ask this. How many times have you seen the same couple, even though, presuming there's a divorce, but the same couple in your court on this issue related to not being faithful to the court order? How many times have you seen that couple?
Well, I'm going to be the anomaly because, as I told you, I have no qualms about sentencing someone. And so now in private practice, because I've been a lawyer for 40 years, in private practice, I saw it dozens of times that we would come into court 2-3 times and not get any sort of punishment on the offender. So that's why when I took the bench 6 years ago, I was like, I'm going to make sure that that doesn't happen in my court. And you'd be surprised how if you sentence someone, and you don't have to sentence them to a long amount of time, you sentence someone to a weekend in jail, that usually cures the problem. And so I have found that to work. We have someone come in and I will sentence them if they are found in contempt. And that's the thing too, they have to meet the requirements because there are strenuous requirements for someone to be held in contempt. You have to meet certain elements. Go ahead, sir.
I hope you don't mind the back and forth.
Absolutely not, sir.
Is contempt findable in that moment, or is contempt yet another docket entry?
No, contempt is findable in that moment because they come into court on a motion for enforcement, and at that hearing, it must be shown that there is an order capable of being enforced, that there is a violation of the order, and that there's intent to violate the order. If I find all three of those things, I find the person in contempt.
They don't go to trial at another opportunity?
No, no. And Mr. Saldana's right. It helps to have an attorney be able to do that because it's a technical type thing. If you make a mistake in how you plead your motion for contempt, the person can skate on the violation because it's a criminal. It's quasi-criminal, which means we want to make sure that all the I's are dotted and the T's are crossed if we're going to put somebody in jail. So it's much harder for an individual who's representing himself or herself to be able to get a contempt finding. But if we did something like this, it would take, by the third time, I think you would have somebody who clearly would get the message.
So maybe my question was appropriate, but because of your experience being prepared to sentence somebody, you've never seen somebody for the third time. Because what I'm trying to
I have never seen anybody for the third time because after I have sentenced them, I never see them come back.
Let me ask your opinion then. Is 3 too high a threshold? Should it be lower? So that if, okay, one time, come back a second? Because it would seem to me that 3 may be too high. I mean, I support the bill if it moves this way, but...
And I understand your position, Senator Birdwell. The bill, when it was originally introduced in the House, had that it was on the second violation. And as a result of what the work in committee, they came up with this, doing 3 strikes instead. But it was originally introduced, and I originally helped draft it as the second time you come back, the judge can't put you on probation. They have to sentence you to jail.
Okay. Now, in the bill itself on page 2, it says the court may not place the respondent on community service or suspend commitment if the court finds the respondent is in contempt. So that when you talked about sentencing somebody, the way I read this is that if they are found in contempt, the original order on the 4th occasion,
Actually, the 3rd occasion.
Third occasion, okay.
Third
so on the
occasion.
3rd occasion, so that you don't have to complete 3, but at the completion of the 3rd.
Right, it would be the 3rd strike. You come into
Because
court.
you're not having to docket it another time.
Two times it's happened before.
Okay.
This is the 3rd time, and you're going to jail.
Okay, but you talked about going to jail. The way I read this, it sounds like confinement is not an option. The way I read this, is that a correct reading?
No, confinement is an option because what happens routinely is the judge will find someone in contempt, sentence them, and then probate the sentence, and they give them probation every time. So that they keep doing that every time, and so there's never a penalty because they're put on probation. And this is saying, look, after the 3rd, you don't get probation.
So this is saying you don't get probation, you don't get the
Correct.
Public, okay, so that therefore it requires a confinement order of some type.
It requires confinement, and as I said, it could be something as short as a day confinement, but it requires.
To get your attention, so.
Exactly, because you can sentence someone for up to 6 months in jail. I've done that a couple times, but not in this situation. But really, putting someone in jail for a weekend is usually enough because they get a taste of what it's like and they go, okay, this judge is serious. I know I need to abide by the court order.
In your court, when the parent seeking the opportunity for visitation, that is not the primary custodial parent, the presumption is that the parent that is not in the primary custodial condition is paying child support. Do you review that plaintiff's payment of child support as part of your review of their request for access and visitation to the child?
No, because there's actually a statute in the family code that possession and access is not tied in any way. You can be completely years behind in your child.
You can be in arrears for...
And still, that doesn't keep you from seeing your child. The legislature has said that.
I don't want that to be... I'm just... What I wrote down in listening to your testimony, I'm wondering, should the bill contemplate such an action? That not that I want the custodial parent to leverage lack of payment against the non-custodial parent, but I also don't want to reward the non-custodial parent for failure being in arrears.
Well, and the legislature said the two are separate, and so if someone comes into court, they can owe support. But I don't look at that. I look at just whether if the only issue in front of me is whether or not there's possession and access that's been denied. Now, I will tell you, in quite often, a motion for enforcement is filed against the custodial parent for violations of possession and access. The custodial parent, if they're owed money, is going to file their own counter motion, and those two motions will be heard at the same time because the custodial parent's going to say, wait a minute, as long as we're going into court, I'm owed money, and judge, I want you to consider that, but I can't hold it against the person owing money in terms of not giving them the opportunity to see their child. The two are separate because we don't keep, if people for whatever reason are unable to pay their child support, that doesn't mean that they shouldn't see their kids.
Correct, okay. So you've heard the discussion here. How many times have you been in court seeking the opportunity to see your children?
I've been in Harris County Family Court for enforcement actions for the last 8 years.
But how many times? I mean, how many
Hearings?
how many docketable? I assume it's a docketable item. How many docketable items is it? Is it too many to remember?
Yes, sir. Yes, sir. I know it's well over 40 times I've been having to drive from San Antonio to Harris County, and that's where that's where my issue is that when I have to drive from San Antonio to Harris County to pick up my child by the conditions of the court order, I call law enforcement because, as Judge said, you need to have a valid order, you need to have a violation of your order, and a willingness to violate. And so 2 of those elements I can meet, but if there's not a law enforcement officer that's going to give me that violation, which I can use in court to prove that, then I can't go to contempt. So in my contempt action that I filed, there was 7 violations. We put a total of 12, and I think the judge just got tired of hearing about them, so she ruled on 7. She placed my ex on community supervision for 10 years. And I'm thinking this is a win. Mom doesn't go to jail. We're going to start following the court orders. Right after that order for probation was given and signed, she violated again. And it's gotten so bad that now these Harris County judges, they're not enforcing the law. Law enforcement's not enforcing the law. But I have mechanisms to enforce this court order, and nobody's doing it. And that's where my frustration
and this may be a question for the judge, and I thank the chairman for his deference here with digging into this. Are the costs of the non-custodial parent, given them multiple attempts, are those collectible as a summation, or is the cost of, if you make the ruling on a docketable item, is the cost of him coming to court for that one time is all that can be collected in attorney's fees, costs, et cetera. But listening to the story, it sounds like years of expenses that will never get recompensed. Tell me where.
Well, and Chapter 157 provides that in most instances, the court is supposed to award costs against the party who violates the court order. But it allows for the court to exercise discretion. And so what happens in the majority of cases is the court doesn't award the attorney's fees. The bill
does.
Says third strike, the court has to award attorney's fees. And the thing about it is the attorney's fees and costs are awarded as child support, which means they can be enforced by contempt. Right. So it's not just a money judgment saying that the custodial parent owes money, say to Mr. Saldana. He would be able to collect it because it's a child support obligation that doesn't go away, and it's enforceable by filing a motion for contempt. It also can be enforceable through income withholding.
Okay. Let me ask one more question,
sure,
Mr. Chairman, and I'll ask it of the judge. I get the sense that part of the reason for this desire not to do something is that because particularly in the large urban areas, judges that get overruled by an appellate judge expect that because they're a judge placed in a position of higher authority. Is there an institutional inertia that a family court judge just doesn't really want to deal with this issue because they don't want to rewrite a peer judge's original order because they're at the same level of district family court? Is there a concern there that judges are just not wanting to deal with this because, well, you know, Jim's sitting on the bench, here's the case today, but Susan wrote the order 6 years ago. I don't really want to, you know, change because Susan's a peer.
It's not that. It's that built into the law, and this is in the area of family law, the standard by which cases are reviewed is abuse of discretion. And that is a very loose standard. And it's just that judges have, in this area, too much discretion, which is why on the criminal side, the legislature has seen fit to put some restrictions on judges. And they've said, look, there are certain instances you're not going to be able to grant probation, even if you want to. Even if you wanted to, you can't do it. There are certain instances where someone comes back 2 or 3 times on a DWI, you're going to give an enhanced penalty. And they didn't leave it up to the judiciary to decide, because I think that's the problem, because judges want to, go along to get along, and they want to try and promote.
So you've just answered the question. The institutional inertia is yes.
It is, because they want people to get along, and it's like, okay, I'm not going to hold you in contempt. You guys are going to work this out. Everybody's going to, it's this Pollyanna attitude. And unfortunately, the people that suffer are people in Mr. Saldana's position, because they're having to keep coming back, and the courts are like, well, I'm doing my best here.
Yeah, we don't live in a Pollyanna world. So
Yes.
Thank you, Judge, for your service. Thank you for the information. God bless you, sir. Thank you for the bill, Senator Paxton. Thank you, Mr. Chairman.
Thank you, Senator Bardwell. Judge, I have a practical question. Of course, your testimony yourself and Mr. Saldana, your testimony is very helpful. So I have a practical question about what you've seen in your court. So I know with the custody situation, sometimes the 2 parents will meet. We'll meet at the Whataburger at X location. We meet there for the handoff. Or one parent will go to the other parent's home or something like that.
Right.
So how many situations do you see where the parent is clearly the one who is not cooperating? Either they don't show up with the child, or the non-custodial parent arrives at the home and the child is not given to them. How many times do you see that versus when the child says, Dad, I don't want to go with you, and maybe the other parent is coaching them, maybe there's pressure on them? How often do you see that situation, if at all?
You see that. I mean, you see it in both instances. Far too often, it's the one parent just not showing up. And in those situations, we often get that it's a combination. Well, I didn't show up for the drop-off because your son or daughter said they don't want to see you. And it's like, well, how do we know that? But it's a combination, and it's completely under the control of the custodial parent, because they've got to transport the child. They've got to be able to bring the child to the location. The child can't transport themselves. And so it really sits with that custodial parent to decide, am I going to meet at the Whataburger? Am I going to do this or not? And that's where we run into a problem, because as Mr. Saldana was saying, most people, when they're been involved, they know they need to do something to prove the situation, what happened, because you show up at the Whataburger, person doesn't show up, how do you prove that you were there? Well, as an attorney, we would say, you go buy something at Whataburger, so you've got your receipt, or you have a police report, right? But so far too often, people get discouraged, they get back in the car, they go home, and then they can't prove that they didn't get their possession and access on that particular day. I see.
And this is all so helpful to us. Let me ask you about that more difficult situation where, let's say the parent, the meeting takes place at Whataburger, but then the child says, Dad, I don't want to go with you. That's more of a factual inquiry, I would think, by the court to determine whether the custodial parent is unduly influencing, that sort of thing. Subject to the rules of evidence and the court's judgment, could this bill be applied in a situation like that as well, if the court was convinced that the custodial parent was influencing that child, coaching that child?
Alienating the child. Yes, it would be helpful in those situations. Yes.
Very good. Thank you, Senator Bardwell.
Thank you, Mr. Chairman. And again, I beg the committee's deference. One question, but in the gentleman's circumstance, Houston, San Antonio are both under the jurisdiction of the state of Texas. What about the issue of the parent, be they custodial or non-custodial, is in Texas, and a different parent is in a different state, particularly if it's the custodial parent in another state? How enforceable is this? What's the mechanism by which the parent that is aggrieved, that seeks this bill, to the parent that is not aggrieved, that's in a different state. How applicable is this? What's the mechanism by which, if it was San Antonio to Baton Rouge, how does this solve it?
The mechanism is Chapter 152 of the Texas Family Code. It's a uniform act that Texas and all 50 states have passed. It's the UCCJEA, the Uniform Child Custody Jurisdiction and Enforcement Act. And it provides that you can enforce a child custody order in any state, and there's a process by which you do that. And so you would have to implement that act if you wanted to enforce the order in, say, California or New York or wherever. You would have to trigger the provisions of that act. It becomes more complicated.
I was going to ask,
but we do have a mechanism for enforcing court orders across state lines.
But at that point, the state of Texas, be it the Attorney General or state law enforcement, solicits at the parallel level, the other state to act?
There are provisions for that. And there are provisions also, depending upon where the order is rendered. If an order is rendered in Texas, it's enforceable in Texas even if the other person moves. And so a Texas court can can file a suit and serve the person in California and say, you need to come here and respond to this violation of the Texas order. Now, if it's like a California order, and the person is in Texas, they take the California order, they domesticate it, they file it here, they register it here, and then Texas can enforce that California order as if it was a Texas order. That's what Chapter 152 provides for.
And then the other states can do the same as if it were a Texas order in Louisiana.
Exactly. And there are provisions in 152 that even authorize, if someone has fled with the child, that authorize law enforcement, the issuance of a warrant to take possession of a child and law enforcement to go seize a child if they've been improperly removed from the state. So it helps in parental kidnapping situations as well.
Okay.
But if the DA doesn't pick up these charges, you lose your kid. And that's the problem, is that the DA is it's just like the House Bill 17 that they wanted to rein in rogue district attorneys for not enforcing marijuana laws and abortions. It's the same thing with interference with child custody. It's a lot easier to utilize the criminal system to enforce that court order, because if you have a right to your child, this is immediate. I shouldn't have to pay $10,000, $5,000, $15,000 to enforce a perfectly good order with mechanisms. And so...
Yeah. Thank you. Thank you, Judge. Thank you, Mr. Chairman.
Thank you, Sir Bordwell. Members, any other questions for Mr. Saldana or for Judge Hayes? Thank you both for being here. Thanks for your testimony.
Thank you.
Is there anyone else present wishing to testify on, for, or against House Bill 3181? Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair lays out House Bill 4157 by Representative Bonin and recognizes its sponsor, Senator Hinojosa, to explain the measure.
Thank you, Chairman Hughes and members of the committee for the opportunity to lay out House Bill 4157 by Chairman Bonin. HB 4157 amends Texas law to align with federal employment law. The bill amends current law to allow employees of spaceflight companies to waive their right to bring claims against their employer. This does not interfere with an employee's right to bring claims under workers' compensation laws. Rather, it recognizes reciprocal waivers as it pertains to spaceflight, which are already required by federal law. While these waivers are likely to hold up as binding in state court, this change will ensure that they are recognized. With the increasing presence of commercial spaceflight in Texas, the outdated statutes of the past are no longer sufficient to ensure liability protections. The proposed bill will update the Texas statute to bar employees of spaceflight companies from bringing claims against a spaceflight entity, but not waive their claims under workers' compensation laws. In addition, the bill affirmatively recognizes federal waivers between commercial spaceflight companies and their customers or passengers. These waivers are essential to allow spaceflight companies to pursue innovation. And with that, Mr. Chairman and fellow committee members, I'm happy to answer any questions.
Thank you, Senator Hinojosa. Members, any questions for Senator Hinojosa on House Bill 4157? We'll open public testimony on House Bill 4157. No one has registered to testify on, for, or against, so I'll ask, is anyone present wishing to testify on, for, or against House Bill 4157? Seeing and hearing none, public testimony is closed. Bill's lit pending at this time.
Chair lays out House Bill 4145 and recognizes Senator Hughes, Chairman Hughes, on this bill.
Thank you, Mr. Chairman. House Bill 4145 comes to us from Representative Dyson over in the House. The bill passed with overwhelming support. This has to do with the healthcare providers and the requirement under law to submit a bill to a patient or other responsible person by the first day of the 11th month after the date the services are provided. Failure to comply means the provider forfeits the right for payment for the service. Of course, that protects patients from unreasonably delayed medical bills. As this testimony knows from other bills and as this committee knows from other bills and other testimony, when someone's injured and gets legal representation in a claim, a healthcare provider may provide treatment under a letter of protection from an attorney. That's where the attorney for a patient who cannot otherwise or pay for health care, an attorney will go to the doctor and say, if you will treat the patient, I will protect your bill, and if we get a settlement or a verdict on behalf of the patient, then I will pay you. And so it's a letter of protection. It's recognized and regulated. And so under letter of protection, that's how it works. But in those cases, the provider might submit a patient's bills to the patient's attorney rather than the patient directly. But since letters of protection often say the attorney is not responsible for the bills, that's situation can fall between the cracks, so that even though a bill were timely submitted by the provider, they could be knocked out of receiving payment that they're entitled to. So House Bill 4145 would just close the loophole by permitting a healthcare provider to satisfy the timely billing requirement by submitting a patient's bill to their legal representative in a personal injury claim by the first day of the 11th month after the date the services are provided, unless otherwise directed by the patient. That's what the bill does, and I'll yield.
Thank you, Senator. Members, questions of the author? Hearing none, we're going to open up public testimony. There is one individual registered, Corey Rose, for the bill. Person, please come forward. Welcome. Please state your name, position on the bill, and you have 2 minutes.
Thank you, Mr. Chairman. And members, my name is Dr. Corey Rose. I am here to testify in support of House Bill 4145 on behalf of myself and the Texas Chiropractic Association. I am a chiropractor in New Braunfels, Texas. Thank you, Chairman Hughes, for sponsoring this legislation. The law requires a provider to send a bill to a patient or other responsible party by the first day of the 11th month after the date of services are provided, or otherwise forfeit payment. This is a good law, and it helps ensure patients get their bills in a timely fashion. However, we're told some enterprising attorneys are using this requirement as a loophole to avoid paying treating providers in personal injury cases, arguing that the provider failed to meet the state's timely billing requirement if they submitted a patient's bills to the patient's attorney, since the attorney isn't the responsible for payment of the bill, even though they are the patient's legal representative. This appears to us to be a loophole in the timely billing statute and not its intention. House Bill 4145 would prevent this loophole from being exploited by allowing a provider to satisfy the timely billing requirement by submitting a bill to the patient's legal representative in a personal injury case, unless, of course, the patient directs the provider to do so otherwise. Thank you for your time and consideration. I'm happy to answer any questions.
Thank you, sir. Members, questions? Hearing none, we're going to close public testimony on House Bill 4145 and leave the bill pending. Mr. Chair.
Thank you, Mr. Chairman. The chair now lays out House Bill 46 by Representative King and recognizes its sponsor, Senator Perry, to explain the measure.
Thank you, Mr. President, or Mr. Chairman and members. This is a follow-up to Senate Bill 1505, I believe, that we passed out here regarding TCUP, or the Texas Compassionate Use Program. It's the House version of that, and it is currently in the works, and we're still having conversations on what the final product is, and there will be a committee substitute, but it is not back from Ledge Council yet. So we will lay this out. Basically, the House bill didn't change the weighting or dosage metrics that we have in 1505. It also allowed for 12 new licenses, where our version, I believe, allowed for up to 6, and added a few new conditions. But again, as I say, this is currently a work in process, and just wanted to have it heard so that when that sub comes out, we can address it in proper time. All right.
Thank you, Senator Perry. Senator Birdwell, you're recognized.
Mr. Chairman, given the chairman's comment, I think what I may best do is, instead, because I had questions, I knew you were thinking about changing it. I have serious concerns with this compared to what
You and several others.
your base bill, but instead of wasting the committee's time asking questions now, I think I'd rather just consult separately with Senator Perry, express my concerns here, see what he's going to change, and then.
It's definitely a work in process, and some of the things in it are a good step in the right direction. Some of the things that are in it are kind of a backwards look, and some of the things in it could open up the door for unintended consequences. So we're just going to work through those, and we got a week or so here to hammer this down. Senate Bill 3 is up on tomorrow in the House, so we'll see where that lands and see where all this fits together. It's all kind of a package deal.
You said, opens the door, so I think it puts a C4 blast on it and
all right,
and opens the door that way. So
appreciate it.
But let's visit, and then I'll await your discretion on the committee sub. Thanks, Mr. Chairman.
Thank you, Senator Birdwell. Any other questions for the sponsor? Senator Perry, at this point, do we need the resource witness, or members have any questions for the resource witness, or is that also premature?
I have no questions, but members may have questions.
Since we have the division chief from DPS, if there are questions, I don't have any, but anybody have any, we'll call them if necessary. Okay. Well, if you need them, let us know. We'll open public testimony on House Bill 46, and the chair calls Nico Richardson, Karen Reeves, Susan Hayes, Mary Elizabeth Castle, Cindy Castilla. Those are the witnesses who have registered expressing a desire to testify on, for, or against House Bill 46. If anyone else wishes to, of course, let us know. Okay, we're looking for Nico Richardson, Karen Reeves, Susan Hayes, Mary Elizabeth Castle, Cindy Castilla. Looks like we have all 5. Ms. Castilla, you're in the pole position, so when you get situated there, remember to get close to the mic since you're on the end. Introduce yourself and go ahead.
Okay, and I have a handout. All right, Texas Eagle Forum is opposed to HB 46 the way it's written. It needs to be significantly amended in our opinion. We do like the addition of background checks that include now owners and members. I'm not sure what that is. Other states have had convicted criminals involved as licensees, and that doesn't go well for their programs in the state. We also appreciate the addition of prescription monitoring. There's not really a remedy, but we are concerned about doctors that would just do this, that they just exist to give marijuana to people, especially with the increase in the adding chronic pain. We would like that stricken. Chronic pain can be faked. There's not a test for chronic pain. We know college kids who've gone off to other states and basically gotten addicted to marijuana through pain and getting marijuana there. So that's important to us. We also oppose the addition of any service member honorably discharged getting to use marijuana for any reason. It doesn't make sense to encourage almost drugging of our warriors. We'd like them to thrive, and we'd like them not to show their family that they're using a substance to get through something difficult. we've taken hits. I'm getting threats and really mean emails over the stand, but it seems to me it shows how much this product is addictive, that people would lash out at those who just want our veterans and families to thrive. So we don't like the open-ended conditions. And inflammation's in there, and I've got a study here, it's an abstract of it, but it shows that CBD and CBG, which don't have THC with them, that they actually do a great job on inflammation. So I don't know that needs to be in here. They don't need THC for that. And this study shows that THC alone does not help inflammation. So I thought you'd be interested in this. Thank you.
Thank you for your testimony, and your testimony was clear. We had you registered as being for, but we need to show you as against.
Oh, I'm so sorry.
No problem.
Oh, yes.
No problem. We got you. Thank you very
Yes,
much.
I did that on another bill. Okay,
No problem.
yes, against. Thank you.
Welcome. Introduce yourself and go ahead.
Hello, my name is Karen Reeves. I'm here to represent myself, excuse me, and the Syntex Community Outreach. I'm testifying in support of HB 46. I've been a cannabis consumer for about 50 years and an activist for the last 13 years, and this is my 6th legislative session to come and participate in. I am an official teacup patient. I qualified for the teacup condition for 2 conditions, neurodegenerative disease and PTSD. Now, I became a patient in 2021. Unfortunately, I'm not currently using the medicine because it's too expensive and does not work for me. And I know I'm not the only one. And I'm here today to continue our mission, Syntex Community Outreach, to be the voice for those who cannot speak up for themselves. We are not criminals. Texans deserve medical freedom to choose a safer alternative instead of harmful pharmaceuticals that our bodies do not need. Now, I support expanding the teacup bill to include new satellite locations and to include more delivery methods, such as patches, lotions, suppositories, and inhalers. Now, for myself, currently, the edibles that are available do not work. My body does not break down the THC in my liver and therefore is very ineffective. Now, I know I'm not the only one. Currently, I use cannabis flower, and I have to buy it off the black market, and I only use about 1 gram of flower a day. Now, I feel confident using cannabis flower because I know that's what works for me. Unfortunately, the use of flower is not included in this bill. However, thousands of Texans can qualify for teacup, but they're intimidated by the process, and getting recommendations is also daunting. Now, adding more conditions to qualify would definitely be an improvement and help many patients who are needlessly suffering without access. And the reason I mentioned cannabis flower is because the majority of people that consume cannabis are using flower, and they're buying it off the black market, and we're able to make other products out of the flower that we purchase. I can't make topicals or suppositories, but I do make a fully extracted cannabis oil that I use at night to help me sleep. So it's very important to have more options. Cannabis is a safer alternative for me. I've been using it for 50 years, and walking into the chamber, y'all would have never known that I was a cannabis consumer. So I appreciate y'all's time.
And thank you for your testimony. Thank you for being here. Welcome. Introduce yourself and go ahead.
Thank you. My name is Susan Hayes. I am here on behalf of Village Farms and myself individually. I am also the public representative on DPS's working group to advise it with teacup, and also came to speak here today in part for one of the patient advocates who could not be here because of a death in the family. We need to truly expand this program, and I know this body is very concerned about the intoxicating hemp market. If you want to take the wind out of the sails of that market, you need to give the people who are using these products for medical reason a place to go and a place where they can have safe and reliable and regulated products. HB 46 comes awfully close to doing that. Already heard concerns about pain. The science on cannabis and pain relief is the strongest science for any condition. It works for pain. It works for pain with THC. And if you do not include it in this bill, then you are pushing that very large portion of the people who are using it out there, veterans or otherwise, back to the black market or back to the intoxicating hemp market. I also want to speak about patient protections. Parents who have children with severe conditions get visits from CPS because somebody at school heard some mama's giving their kid marijuana. They have no ready way to prove that they are in a program legitimately, and their family has to go through a very traumatic and invasive investigation. There are ways to document that and document it quickly. I would love to see this bill amended, and I'll be happy to follow up with Senator Perry's office on that, to make that quick and easy for these families instead of an excruciating ordeal. That is all I have, Your Honor. Sorry, Mr. Chairman.
Thanks for your testimony. Welcome. Introduce yourself. Go ahead.
I'm Nico Richardson. I'm the CEO of Texas Original Compassionate Cultivation. I'll keep this incredibly brief because we're still working on, you guys are still working on bill language. We're supportive of the conversation between—
Get a little closer to the microphone.
We're supportive of the conversation between 1505 and 46 here. Three main things that this bill did that we thought fixed the system in a big way were adding accessibility through satellite locations, allowing for pulmonary inhalation, and really the combination of the two of those things is lowering the cost of the medicine for patients. So we're in support of the conversation. Anything we can do to help or be a resource, we're happy to do that. Thank you. Give my time.
Thank you. Ms. Castle, welcome back. Now remember, on the end, you got to get close. Introduce yourself. Go ahead.
Good morning, Chairman Hughes and members of the State Affairs Committee. My name is Mary Elizabeth Castle. I'm Director of Government Relations for Texas Values, and I'm testifying against HB 46. Texas Values is the largest organization in the state of Texas that represents faith, family, and freedom, and we have long held the position at our organization to oppose any expansion of marijuana or cannabis, especially when it could be expanded to recreational use. And this piece of legislation is simply a waste of time when the legislature has so many other pertinent issues that they need to address. There's just a bad practice of prescribing cannabis as a cure-all for chronic diseases without addressing possible effective remedies. This seems like it's doing the opposite of what the Lieutenant Governor was trying to accomplish with SB 3, which was one of his main priorities. And the Senate just recently passed a Make America Healthy Again bill. In that case, with that philosophy, diseases like Crohn's disease should be addressed by diet and lifestyle changes and the appropriate medicine, and not by just a cure-all of prescribing cannabis. Also, when it comes to criminalization, the verdict is still out whether research shows that cannabis is a gateway drug to other harder drugs, but I can account many allegorical examples from where I come from where this has been a proven fact. When it comes to other crimes as well, these type of bills never lead to fewer arrests or dealers from less economically prosperous neighborhoods becoming savvy businessmen. In fact, it becomes basically between a war of people who have licenses and people who don't attain licenses, and the people who don't attain licenses are still criminalized. So there's no proof that it would lead to less criminalization or fewer arrests. In fact, there's even research from Kylie E. McCarthy from the University of New Haven that showed in Colorado and Washington, where they had more dispensaries, that the crimes of larceny and robbery actually increased, and those crimes were against those dispensaries. So with all of that, I ask that you vote no on HB 46.
That's nice for your testimony. Senator Perry, you have the panel.
Yeah, I just want to be clear. My position on TCUP and the Compassionate Use Program has not changed. I'm a supporter. I go back to Charlotte out of Colorado that started this conversation. I think she passed due to COVID or something like that, but the multiple episodes of seizures and epileptic stuff or some weird version of that. And I think last night on the news there was a Child Here local resources that because of those, the TCUP program, that child can function normally and have a good day. So there are legitimate uses for this particular product. And I will say Texas Original, not supporting any one vendor, but you're kind of the remaining one of the three that is actively in this business today, and you're hanging on because of the unregulated, hope soon to be closed market on the other bad stuff that's given this stuff a bad rap. But this is a unique plant. It has a whole lot of different stuff in it. And what I encourage those that are against banning and closing this stuff down, instead of spending your money on addiction and ruining people's lives, put that money to research on the various strains of this stuff that ultimately probably has as much medicinal use as any of the other drugs we prescribe for these things. But the dollars go to where the dollars make more dollars, and that's unfortunately where it's at. So I say all that to say 1505 and this bill both wants to expand access in a responsible way to where you're not driving a product from Austin to Lubbock only to have that person not on the recipient end of it to have to drive back. That is a legitimate prescribed by physician affliction named in statute that could benefit. So we're there. Unfortunately, it's contingent upon some things that we don't control, some things we do. But this particular drug is like no other drug that has come to the market. It needs its due research and time, and it does need to be heavily regulated and prescribed. And so when we go down this road, I think that's where we want to be because it has shown promise for, honestly, people to date had no help. The only differential in this and the Right to Try program is those people are terminal. Well, we're all terminal, if we're honest. But I want the members to know my position hasn't changed on getting help where those that can benefit under a regulatory environment that guarantees success. And hopefully over time we'll parse out these individual biological components of these plants to figure out good, bad. And that's what we don't have today. And I hope that's where we go long term. But today, you guys need expanded access for the legitimate users under the prescribed market of a physician. And I hope that's where we land this plane before we leave today, or this session. So we'll see. But I just want to be clear with members, my position's not different. And I think we're in a good spot on both 46 and 1505, finding that happy balance subject to some other things needing to happen. So appreciate you being here. I appreciate you being the kind of the lone survivor of the 3 licenses, really.
Appreciate you. Thank you.
It's not cheap to do this, and that's passed on to the user groups. So I think there's just this misnomer, and you're attached to bad people. And hopefully we get rid of that attachment this session.
Thank you, Senator Perry. Senators, any other questions for any of our witnesses on this panel on House Bill 46? Very well. Thank you each for being here. You're excused. Thanks for your testimony. Is there anyone else wishing to testify on, for, or against House Bill 46? Seeing none, hearing none, public testimony is closed. Bills left pending at this time. That concludes our posted agenda for this morning's hearing. We will continue to be moving bills through the process, and so senators be watching for notifications of meetings to vote as we'll do this week. And with that, with great thanks to our excellent committee staff, each member and their excellent staffs, and the Senate team that gets everything in place and keeps this broadcast and keeps everything working like it's supposed to. And thanks to all the witnesses, wherever your position on, for, or against. If there's no other business for the Committee on State Affairs, the committee stands in recess subject to the call of the chair. Good morning.